Good afternoon, everyone. Thank you for joining us today. We are going to speak about COVID-19 employment law issues with you. And before I begin, I hope that you all are staying safe and healthy during this very uncertain time. Before I start, I'd like to say a brief thank you to our friends. We have had friends, institutions, individuals that have helped promote our webinar, spread the word about it, and we like to thank them. So thank you all for helping to support us. After this webinar is finished, you'll receive a copy of the video and in an e-newsletter, and you will also receive a link to a survey. We ask you to fill out the survey and submit it to us. And to thank you for your time, we will send to you a Starbucks coffee card or $5 gift certificate. It looks exactly what you see on the screen here, or a Walker Law branded face mask. We ask you just not only to fill out your address, but please provide a few comments. This is the way we learn. This is what we find out, what you like, what you don't like, what you want to hear about. So just to thank you for your time, please fill it out. We have also partnered with a charity called Renewed Computer Technology. So if you have any technologies just sitting around your home that you're not using anymore, we ask you to consider donating it to us. We'll wipe it clean before we submit it to Renewed Computer Technology. Renewed Computer Technology is funded by the federal government, and it donates used computer technology to young adults. So for those young adults or children who aren't in school, who may not even go back to school in September, who knows, they'll be able to continue to learn. In our newsletter that we will also submit to you, we will provide a few links of a few upcoming webinars. On Monday, I'll be presenting on solely really real estate law. July 21st, 22nd, we're still working out the date. If you are a lawyer that's signed in and a member of the Ontario Bar Association, I'll be speaking about property litigation. At the end of the month, I'll be speaking for McMaster University on negotiations. And next month, we'll be providing updates on employment and property law. So please join us. Our previous material is also available on a YouTube channel, so I ask you to consider subscribing. I was on TV probably around 2 or 3 weeks ago speaking about jury trials, and that's on the YouTube channel. So if you do subscribe, you'll be notified, or you can view other previous webinars. So our agenda for today is as follows. We'll provide a brief housekeeping introduction to our team. Then I will provide an update on government's response to COVID-19 with a focus on employment issues. Then we will answer your employment law questions. So this webinar is customized. All of you, when you registered, you were asked to submit some questions or what do you want to know? And for those of you that submitted a question, we have put all the answers in this webinar. To keep things confidential, you'll see your first initial and last initial in some of the questions that we answer, but it's all answered, it's all in there. So please keep in mind that this is a customized webinar. We'll speak to you about the Uber case. That's a Supreme Court of Canada case. It's binding across the country. We'll also discuss notice periods for non-continuous employment. So that means if you leave a job and then start the same job again and you're terminated, how much pay can you really get because of that? Understanding buyers' obligations, business owners' obligations regarding COVID-19 protection, the infectious disease leave, it's a new regulation, and what to expect if you quit during COVID-19. We will answer your questions along the way, but I want you to keep in mind that you should fill out the chat. If a question comes to mind, you don't have to wait until we pause and ask are there any questions. We will pause after each topic to answer any questions, but feel free to write it in. Rishi Nagashar will answer as we go along in writing, and we'll read some out loud. For those of you who have not participated in our webinars before, we like to keep you engaged and involved. So what we do is we have a series of polls. There are 5 in this webinar. And so we'll ask you to vote on what you believe the correct answer is or what your opinions are, and then we'll share them with everyone. So when you see a poll pop up, click on the answer that you believe is correct and hit submit. So our roadmap for today is as follows. We will, after the legislative updates, we will have a poll to understand your perspective. We'll discuss the law and the correct answers, and we'll discuss how to protect yourself or some tips on how to go forward. Before we move on to the other topic, then we'll answer any questions. So after this webinar is finished, you should understand how the Supreme Court of Canada's Uber decision will impact employment contracts, the impact of non-continuous employment on your termination notice period, what your obligations are as an employer to provide protective masks, the new infectious disease leaves, you should understand that, and what to expect if you quit during COVID-19. So just a brief introduction to us. I am the owner of Walker Law. I created this firm 10 years ago after practicing at two Bay Street firms. I'm fortunate to be a legal analyst on several television stations, which includes CTV Your Morning, CBC, and CP24. Jordan Koenig is an employment lawyer with our firm, and he's also a panelist. We're very fortunate to have him here today. And Rishi Nagashar just got called to the bar. Congratulations, Rishi. He articled with our firm, and he'll be speaking on a topic today as well. So before we begin, I'll pull up a poll and I will ask you to vote. What employment issue concerns you the most? Termination pay for non-continuous employment, employers' COVID-19 duties to their employees and or customers, being terminated without cause due to COVID-19, or quitting your job during COVID-19, or other. Just let us know using the chat. So let's take a few seconds and I'll ask you to vote. And I'll end the poll in about 5 seconds. So sharing the results with everyone, the majority of you are concerned about being terminated without cause due to COVID-19. And for those of you who are concerned about being terminated without cause due to COVID-19, please let us know using a chat what concerns you. Is it the pay in lieu of notice? Is it finding another job? Is there anything that we can answer while we are in this webinar today? Second is quitting your job during COVID-19. So please let us know what are you concerned about in regards to quitting your job. And next is employers' COVID-19 duties to employees or customers. So we'll make sure we spend more time on those particular topics. Other, please let us know. So before we begin going into the different topics, I will provide to you an update on the legislation. So looking at the federal government, and keep in mind, this is, we had a webinar about a month ago. So these updates are since last month. So starting off with the federal government, there's a relief for employers who sponsor the registered pension plans. And what that means is the goal of that was to encourage employers not to lay off employees because they would have more disposable income. So employers who have registered pension plans are permitted to borrow money, defer plans, defer payments, so they can catch up in the future. That's the goal. Second is proposing requirements for large companies to ensure fair labor practices. So if you own a company, but this is a larger company, and you have a supplier, it doesn't matter where your supplier is, the federal government is contemplating having those suppliers properly compensate their employees. So if you're responsible for buying from a supplier, the employees of that supplier have to fairly compensate their employees. And also there's the extension into CERB until the end of August. So now it's 24 weeks. Provincial laws that have been implemented is that the state of emergency has been extended to July the 15th. There's a possible extension to July 24th. Our premier has said that he doesn't want to extend it into August. So we'll see what happens. There's also the Connecting People to Home and Community Care Act, which has received royal assent yesterday. So what that means is this protects people in long-term care homes. And if there's an investigation that the investigator believes that the home is not cooperating, they're allowed to, for example, get a warrant from a justice of the peace to actually enter into the long-term care home. There is also infectious disease relief, which I will discuss later on in this webinar. It's a little bit more extensive. And there are a few proposed laws that you should be aware of. One is the residential tenant law, Bill 184. It has passed its third reading. It's a bit controversial. You may have heard people were protesting outside Mayor Tory's condominium because they were concerned about this. We will discuss that extensively in our webinar at the end of August, the property webinar, and I'll also discuss that on Monday if you decide to sign up for that webinar regarding real estate, property, and real estate issues. The Seniors Advocate Act, Bill 96, that received its first reading on Tuesday. So what that means is they may have an independent officer of the Legislative Assembly, which will help promote concerns of seniors and their family members and make reports to the public. So it's more of a liaison. So that passed its first reading on Tuesday. Residential tenant law passed its was ordered for a third reading the day before. So in regards to the City of Toronto, face coverings are now mandatory. So please be aware it's face coverings, not face masks. So face coverings could be like a scarf. The fine is $1,000 per offense. And Jordan will speak about that a little bit more later. There are also automated speed enforcement systems. So these systems have been around for the past couple months, but they weren't actually really active in terms of ticketing people. And between January to last week, they said around 150,000 infractions actually happened. So now there will be tickets. There are 50 automated speed enforcement cameras throughout Toronto. Now, moving on down to the courts. So we're trial lawyers, and the courts are important to us. The courts have reintroduced in-person hearings very slowly. If you do have to attend court, you will be screened for COVID-19. Different courts have different rules. For example, our paralegal attended court yesterday to file some documents, and the court in Toronto said we will only permit you to file 2 documents per day, 2 filings per day. So it's important to call ahead because that isn't necessarily listed online. Also, evictions may take place at the end of the month, and this is a big one. So with evictions, there was a pause if you already received an order to evict your tenant or evict the person who wasn't paying their mortgage. And what was ordered a Monday or Tuesday earlier this week, is that once that state of emergency is no longer around, you can enforce that eviction. So what that means is if the state of emergency ends on the 15th or even on the 24th, as of July 31st, you are able to enforce your order to evict a tenant. That doesn't leave a tenant much time to find somewhere else to live. Also, there are proposed changes that affect the Ontario courts. There is one where there is a consideration of ending civil jury trials, and that's what I spoke about on your morning about 2 weeks ago. Ontario is considering preventing lawsuits against good faith infections. And we're kind of copying, looking at BC, British Columbia, in terms of doing this. What it means is if you are an employee and you go to work and you may have gotten COVID-19 and their precautions were made for you not to get it, there's hand sanitizer, the policies are in place, you may not be able to sue your employer for any damages resulting from COVID-19. So that is in effect in British Columbia, and that might be in effect here in the future. So we'll move on to answering your employment law questions, which is part 3 of our webinar. And I will let Rishi speak to this topic.
Hello, everyone, and thank you, Tanya. So the first substantive topic that we will discuss today is the Uber case, or related to the Uber case. Many of you may have heard about this in the news, but before we begin, we'd like to have a poll to understand what you think the court decided. So the question is, from the perspective of an employer, you have an employee in Toronto who signed a contract in Toronto, but a contract says that any disagreements between the employee and the employer must be dealt with in the Netherlands by arbitration. Was this arbitration agreement valid? The potential answers are yes, no, you do not know, or you're unsure. Please select an answer. We'll wrap up in a couple of seconds. Okay, Tanya, do we have the poll results? So it looks like a lot of you thought that the arbitration agreement was not valid. So maybe some of you have heard about the Uber case a little bit more than others. Next slide, please, Tanya. So the correct answer is that the arbitration agreement was not valid. And what's important about this is that employers should know that even if you contract with your employees, the court has the ability to determine that parts of the contract are not enforceable. And what's really important are the reasons that the court decided that this part of the contract, the arbitration agreement, was not valid. Ultimately, the court decided that the arbitration agreement was not fair. And there are a number of factors that determine fairness for employment contracts or phrases in an employment agreement. So the biggest issue that the court had was that practically Uber drivers would not go to the Netherlands to have a dispute resolved with Uber. The court did not like this because it meant that the dispute, an active and real dispute between a potential employer and employee, would never be heard. The arbitration agreement also would cost each Uber driver $15,000 in fees, and that's before they hired a lawyer, before they travel to the Netherlands, or before they get any accommodation once in the Netherlands. The other factors that employers will want to keep in mind about why the court would be willing to strike down part of an employment agreement is that the drivers got no legal advice, while the employer, the much more powerful entity, was able to have the assistance of many lawyers. Also, in many typical employment agreements, you're able to negotiate certain clauses with your employer. For example, you can discuss pay, you can discuss vacation, time, or benefits and other entitlements. For Uber, the Uber drivers had no ability to change the agreement. They were forced to take the agreement as Uber presented it to them, or they were not able to drive for Uber. The courts determined that the imbalance in bargaining power should be resolved in favor of the Uber drivers. So employers should really keep these factors in mind when they're thinking about drafting contracts or including clauses in a contract that they think favor them, but the court always has the ability to decide that certain contracts should not apply, or certain parts of a contract should not apply.
Thank you, Rishi. Sorry, go ahead.
One of the things that employers should keep a lookout for is whether or not the government will respond. So several years ago, the government made changes to the consumer protection laws in Ontario. And one of the changes that they made was that a business cannot force their customers to arbitrate in a different country from where the contract was made. So it'll be interesting to see if the government makes this exact same change for employment contracts in Ontario as well. And I believe we may have had a question that we could look at. And yes. we'll answer that question if we get to the end of the section.
Okay.
Next slide, please, Tanya.
Well, this is where we answer the questions, but before we move on to that, Rishi, since you're at this point, there's a question from Yannick. Thank you for your question. She mentioned that it was held invalid because it was unfair. Can it otherwise be invalid? Can it otherwise be valid?
Arbitration agreements can be valid. A lot of courts will actually uphold arbitration agreements because they find that arbitration is generally quicker and cheaper. However, what the court took issue with and what they found to be unconscionable or unfair was that in this case, Uber knew that their arbitration agreement would cost more money and likely take more time. They took advantage of something that was intended to help people resolve their disputes and use it to prevent disputes from actually being resolved. So to answer your question, arbitration agreements can be valid in the right context, but not when they force less powerful parties to essentially abandon their dispute or their claim with their employer. Hopefully that answers your question.
Thank you, Rishi.
So we received two questions. One was this morning and the other yesterday, I believe. So the first question is, what is the best course of action for terminating an employee that is near retirement? And this question comes from WL. We'd like to thank you for submitting that question to us. So the best course of action would be to consider negotiating a retirement package for that employee. The benefits of a retirement package is that you can negotiate certain things that the courts will not do for you. You can also negotiate a smaller termination period. So for example, if you were thinking of terminating an employee and they were entitled to 1 year of notice or 1 year of severance, you can negotiate 8 months, for example. This might be enticing to that employee because then they could avoid a lawsuit, they could avoid a dispute. Employees are also interested in retirement packages in our experience because you can include things such as health benefits or other factors that the court will generally not order for employees. The courts generally will only give you, will only order a monetary amount, but nothing else. So negotiating a retirement package is often the most favorable way to proceed. One of the things that you should consider when it comes to negotiating a retirement package is pensions. If an employee was planning to contribute to a pension over the next couple of years of their employment, they need to calculate whether or not they'll actually have enough pension contributions to retire comfortably. This is something that the employer could assist with and the employee can work together on to come to a more reasonable solution than having to deal with termination through the courts. The other question is, how do you deal with severance pay at age 60 and above? And this question comes from TD. We'd like to thank you for your question as well. So one of the things that employers should know is that employees who are older are entitled to more termination pay than employees who are younger. The courts generally believe that older employees have a little bit more difficulty finding alternative employment or a new job or starting a new career. So for this reason, unless part of the contract limits the employee's entitlements to what is mandated by the Employment Standards Act, employers should be aware that terminating an older employee can result in larger notice payouts. Next slide, please, Tanya. So before we proceed, are there any other questions?
Rishi, there was a question that I saw, and I might answer it, or you can let me know if you'd like to answer it. So it says, it's from TW, currently working in sales, which is commissioned, but business is slow and being harassed to do increased sales during a pandemic and hiring younger sales staff with a lower commission scale. This is forcing you to quit, but minimum opportunity to find a new job. Therefore, you can continue showing up and getting a salary of a minimum wage. What can I do? It is a difficult environment by the management team. Richard, do you want to answer it, or would you like me to answer it?
I can answer it, and you could add on to anything that you think was missing.
Go ahead.
So it sounds like the employer wants you to continue to meet your sales targets, and that can be a valid requirement. One of the things that you might be considering is whether or not these new requirements or operating procedures results in constructive dismissal. And it'll be hard to make a case for constructive dismissal simply because the employer was hiring additional employees or making the work environment a little bit more competitive by offering the new employees lower thresholds for their sales targets. I don't think that there is any ability to force the employer to change the way that they're structuring their compensation agreements, for example. Tanya, feel free to add anything that you would like.
No, that's exactly what I was going to answer. So thank you, Rishi.
Thank you. And thank you for the question. Next slide, please, Tanya. So one of the questions we received a couple days ago that we decided to provide a substantive answer for is termination periods for non-continuous employment. So the question is, I started to work in 2008. I took 2 years off in 2014 to go to school, and I was fired in 2020. Is my severance calculated from 2008 or from 2014? Please select one of the answers. The available options are 2008, 2014. It depends on the circumstances of going to school, or you're unsure.
So could you please vote, and we'll give you a few seconds to answer. And we will end it in about 5 seconds.
So it looks like the two answers are 2008, and it depends on the circumstances of going to school. Thank you for providing your answers. Tanya, please let them know what the correct answer is.
Sure. The correct answer is C. It really depends. Let me just back up a little bit here. So the starting proposition is that you have the Employment Standards Act, and the Employment Standards Act says that for every 1 year you've worked, you should receive 1 week of pay in lieu of notice if you're terminated, up to 8 weeks. Courts decided that's not enough time and have created their own law, which is called the common law. And so what the common law says is roughly 1 month per year that you've worked there, depending on factors such as your age, what level of employment that you held, and how long you've been there. So, for example, someone who says 60 years, someone who's an assistant who's 60 years old may be entitled to more of a common law notice period than someone who's 20 years old. And this is the goal of this, is just so you can keep on paying your bills until you find another job. You're supposed to be actively looking for a job. So, and it really depends on the reason why you went back to school. Did you go back to school because you were supposed to continue on working there? Many of us as lawyers, we summer somewhere we summer at a job, we go back to school, we continue to article there, might go back to school or take our bar and then continue to work there as an associate. So it just depends on the reason. And did you actually quit, or did you intend to come back? So the leading case on this was decided last year, and it's the Berg, Lindsay versus Kucher Dentistry. And it's really an interesting one because she actually resigned but never stopped working. So she resigned because she got engaged. She was supposed to move across the country, but her engagement was called off. So she continued to work. She signed a new contract. And here the Court of Appeal, and keep in mind, Court of Appeal is the highest court in Ontario. It's binding on the lower courts. They said that your notice period would have started, or your time of calculation started from the moment you signed the new contract. So many of you in the survey, you said your notice period in this situation would be 2008. If that was a situation applied to that Court of Appeal case, it actually would have been 2014. So it's important to know this, that if you take a break in your employment, you return and it's not made abundantly clear that your employment continued on, if you're terminated, it only might be calculated, your salary, from the moment you return back to work. So tips for employers going forward. Employers, if your employee leaves, make sure it's clear that the job has ended. If they return back, make sure it's clear that it's not continuous from the moment they left. For employees, what you'd want to do is have it be continuous. So if you leave a job, or even if you don't leave, you quit and then you still are working there and you sign a new contract, you probably want it in your contract that the time before that continues on. So if you're terminated, it will be calculated. So Jordan, I'll leave it to you to speak about recourse for employees.
Thank you, Tanya. So we have another question here from FO. I thank you for your question. And it states, is there any recourse for employees who are expected to accept on-call shifts when they're available, but are not guaranteed a minimum set of hours? Now, as with many things in the employment sphere, one of the first things you want to do is look at the employment contract. If you're classified as a full-time employee, then your employer is required to provide you with full-time hours. Similarly, if the contract says that you are required to make yourself available for on-call shifts, you are required to do so. Now, previously, up until fairly recently, employees did have the right to refuse shifts, including on-call shifts, that were scheduled within 96 hours of the time that the shift was due to start. And also, employers were required to pay employees for a minimum of 3 hours work for any 24-hour period in which an employee was on call. However, those laws were introduced by the previous provincial government. And when the current government came into power, they introduced the Making Ontario Open for Business Act, and that effectively reversed those laws. It's really a very employer-friendly act. And so at this point, there really is no legal recourse that's available to on-call employees. Employees can even be fired if they refuse to show up for an on-call shift. However, in order for such a firing to be considered with cause, it would likely have to be a sort of a repeat occurrence and something that the employee had at least been warned about, if not reprimanded for in the past, particularly if there is a policy that the employer had dealt with this issue and the employee was aware of it. Such a policy would either be included in the employment contract, or it may be a standalone policy that the employer would provide to all employees and ask them to sign a sheet confirming that they'd seen it, just so they have proof that the employee was aware of such a policy. I hope that answers your question. Next slide, please, Tanya. Are there any other questions at this point before we move on to the next topic?
I don't think that there is, so we'll have you move on.
All right. Okay, so we've got another poll coming up here. This one deals with an employer's obligations regarding sanitation and personal protective equipment. So it says, what obligation does the business owner have to provide protective face masks to employees and or customers? And so your options are A, they must provide face masks. B, they do not need to provide face masks. C, it depends. Or D, unsure. And we'll give you a few moments to plug in your answers.
So we'll give about 5 more seconds and then we'll end the vote.
And so I see about 69% of the attendees think that it depends. And if we flip to the next slide, you'll see that the majority was right here. It does depend. So as Tanya mentioned earlier in the legislative updates section of the webinar, as of this past Tuesday, Toronto has enacted a new bylaw that deals with the requirement for wearing a face covering, not strictly masks, any covering is fine, in certain confined places within public. And part of the bylaw, one of the things it does is it imposes a duty upon owners of establishments that are open to the public to draft and enact a written policy that prohibits members of the public from entering or remaining in any enclosed space within their establishment without protective covering. Now, employers or owners of establishments should be aware that they could be required to produce their written policy, a copy of it, to be inspected upon request by any individual with the authority to enforce the bylaw, such as a bylaw officer. Now, with regard to any duty to supply the mask to employees, it hasn't yet been legislated. There is no law that forces employers to provide the mask to employees. But if they're required to wear them in the workplace, it's something the employer really should do. Well before this new bylaw was enacted, there was already a general consensus in the employment law community that if an employer is going to require their employees to wear a face mask at work, then they should provide those masks. Now, when it comes to any duty to provide face masks to members of the public, such as potential customers, there is no requirement, legally or otherwise, for owners of establishments to do so. But again, it's something that they would probably want to consider just because it might make good business sense, particularly if the establishment is a retail store and it sells goods. If you think about it, if you're the owner of a retail store and a potential customer wants to come into your place of business, but they don't have a mask with them, if you provide them with the mask and they come in, even if they only make a single item purchase, it's probably more likely than not that the income generated from that one purchase will already outweigh the cost that you spent providing them a mask. So it's probably best practice to have masks on hand that you can give to potential customers. Now, there are a number of exemptions to the requirement to wear facial covering, and a number of them are listed on the next slide. Here we are. I won't list all of them because you can see them in the slide, but a few noteworthy ones are that children under 2 years old are not required to wear facial coverings. People with underlying medical conditions are exempt, particularly people who wearing a mask might cause them to have difficulty breathing. Also, people who are unable to put on or remove a mask without assistance. That's likely because if they require assistance to put it on, that's going to eliminate social distancing, and it sort of defeats some of the purpose, which is protecting the public. Now, there are also a number of businesses that will be exempt completely from the act, or the bylaw, sorry. Those include schools, post-secondary institutions, hospitals, and other medical professionals' offices, private and public transportation. The TTC in particular actually has its own separate bylaw. And there is also temporary exceptions to the requirement to wear a mask. So if you're in a place that would normally require you to wear a mask, you are allowed to temporarily remove it so that you can eat food or take a drink. Another temporary exception is if you're doing some physical exercise, you're allowed to do that without the mask on. One exception that was sort of surprising to me was that workers in kitchen restaurants are not required to wear a mask so long as the kitchen area is separate from the dining area and it's not accessible to the public. I would have thought that one of the people you'd want most to be wearing masks would be those handling and making food, but apparently I'm wrong, and you can take that information how you will. One thing that is very important for operators of establishments to know is that if someone is in your place of business and they're not wearing a mask and they claim that one of the exemptions applies to them, you are actually forbidden from requesting that they provide some sort of proof that the exemption does apply. So, next slide, please, Tanner. So there are some other duties that the bylaw imposes upon owners of establishments. And one is that signs that give notice of the mask or face covering policy must be posted at each and every entrance to the establishment. These notices must be posted conspicuously so that anyone who is entering your place of business can see and read the notice. There is specific language that must be included in every single notice, and it's listed in this slide here. I won't read it because you can see it for yourself, but different businesses can enact their own policies, but it has to include that specific language. Failing to follow the terms of the bylaw is an offense that Tanya mentioned earlier can result in a $1,000 fine. So it's very important that operators of establishments ensure that all of their employees are well trained, both in their business's individual policy and the actual bylaw itself. And this is because if one of your employees is caught not wearing facial protection in the place of business, then it is actually the business owner who will be subject for paying that fine. Mayor Tory has actually come out and said that this bylaw will not be aggressively enforced, simply because the city does not have the resources to send bylaw officers into each and every public place and ensure people are wearing masks. But that being said, if you are found to be in violation of the act, you could be subject to that $1,000 fine. Next slide, please. So we have another question here, and this one comes from AM. It states, I own an auto electric business that shut down in March and reopened in mid-May. I've been paying my employees, but have not taken any pay myself since mid-March. Any money coming in has been put back into the business to keep it afloat. Can I do this and also collect CERB or CERB? And another somewhat related question is NZ would like us to discuss some pros and cons of being self-employed. There is some overlap, so I'll address them together. And thank you, AM and NZ. So the simple question, or simple answer, is that yes, AM could be eligible to collect CERB as long as the other requirements of CERB are met. And the main requirements are that in the first 4-week period that you're applying for the CERB, you must have stopped working as a result of COVID for at least 14 consecutive days. And in that 4-week period, you must not have brought in more than $1,000 in employment or self-employment income. So since AM here shut down business in March and resumed operations in mid-May. The 14-day stoppage requirement is clearly met, and he hasn't been paying himself any money. So yes, he would be eligible for the CERB. And that brings us to sort of one of the pros of being self-employed. And I should mention this only really applies if you're incorporated. If your business is incorporated, you can choose how much you are paid in salary. And you can still have funds or income coming into your business and still be eligible for the CERB yourself, as long as you're paying yourself a salary that does not exceed $1,000 in the 4-week period. Now, I should warn you, if you're a sole proprietorship, the income that the business makes is treated as your own individual income, so it's not the same situation there. And I should also warn that there is a risk of auditing. We've been told that the federal government has hired thousands of auditors specifically to investigate possible fraud related to CERB payments. So it's kind of up in the air right now, but there is a possibility that you could face some consequences if it can be shown that you're intentionally manipulating your the amount of your salary solely for the purpose of being eligible for CERB. I hope that answers those questions. Next slide, please. Are there any further questions?
Jordan, there is one from Kamal. One of the requirements of CERB is that you earned a minimum of $5,000 before taxes in the last 12 months or in 2019. Does this have to be Canadian income? For example, if you worked in another country in addition to working in Canada. Do you know the answer to that?
I haven't come across this question before, so I can't give concrete legal advice on that, but my impression would be that the minimum of $5,000 would apply to income that is taxable in Canada. But again, we can look into that further and discuss it in a further webinar, or perhaps reach out to KP individually and provide him with our answer.
Okay. Another question that we have is, if an employer has to provide face masks, are there any quality requirements like single cloth, double cloth, medical grade?
There are not, at least under the bylaw. The bylaw only requires face covering. So that, as you mentioned earlier, Tanya, that could be a scarf, a bandana, something like that. Certainly, it wouldn't have to be medical grade. I know the chief medical officer said at some point that a medical grade, I believe they're called P95 masks, should not really be used by the medical or by the general public. They should be reserved for medical professionals, since they are sort of in short supply. So no, there's no requirement of the quality of face masks that an employer should provide.
Okay, we'll move on. Thank you, Jordan. So I'll discuss infectious disease emergency leave. And before getting into the poll, I just want you to understand what it is. So it protects, it's a regulation that protects employers and employees. How it protects employers is that if an employer usually lays off an employee for more than 13 weeks in a 20-week period, that employee can say, I'm terminated, or ask for severance pay. So I mentioned earlier the common law, 1 month per year that you've worked there. At that point in time, after 13 weeks, an employee would be able to ask for this. Now, how it protects employers is that if you lay off an employee due to COVID-19 reasons, the employee cannot sue you or ask for termination pay or severance pay. And this is indefinite. There's no limitation on this right now. Now, how it also protects employees. And how it protects employees is that if an employee has to self-quarantine or actually gets COVID-19, or think that he or she may have COVID-19, an employee is protected. Their job is protected. It's unpaid leave, but they cannot be terminated or harassed because of this. So that's how it protects both employers and employees. So knowing that, I'll move into the question. And the poll is, pull it up here. Can an employer ask for proof that an employee has been quarantined? So the job is protected, but now does the employer have the right to say, well, give me proof? Yes, no, none of the above, or unsure. Please answer. And I'll give it about 5 more seconds. And the answer, the majority of you answered yes, that 50% of you said an employer can ask for proof that an employee has been quarantined. So the answer is yes, majority of you got that right, but it's reasonable proof only. And so what an employer cannot ask for is a doctor's certificate. So, but in terms of reasonable, we have to look to British Columbia for guidance because this regulation is fairly new. It came into effect in May and it's retroactive to March. So when looking at BC, reasonable is if someone says, I am quarantined because I have COVID-19, you might be able to ask for test results. In British Columbia, if you might be able to ask for a copy of the passport if the person is quarantined due to recent travel. Also, if someone else is quarantined in your household, you may be able to ask for public health correspondence. If you are feeling the symptoms, you might ask for what's the self-assessment tool, like do you have a fever? What makes you believe that you might have this? So employers are really encouraged to be very flexible when enforcing this because it will help stop the spread of COVID-19. So some tips for employers. This is the biggest mistake that I've actually seen in my 14 years of practice when it comes to employers. Employers are very, very busy. And the problem is that the disconnect is that judges need evidence. They need paper. When I go to court, when I go to a trial, I need as much paper to demonstrate my side of the story, my client's side of the story. And so it would be great if employers would create policies, even if they're not required by law, create them anyway, having an acknowledgement that from employees that they agree to those policies, document as much as possible, and really don't force anyone to come back to work. If an employee, same thing with the employee, I represent employees as well, and it's helps an employee's matter if the employee has documentation, if emails were sent regarding certain concerns the employee has. So then when they come to me and I'm trying to negotiate with the employer, I have evidence to show where we're coming from or why we're entitled to what we are. So Jordan will answer this question. One question is from NG. Under what circumstance can employers lay you off or fire you without compensation? So we have about 12 minutes left, so we have to go through this very quickly.
Okay, so very quickly, we should differentiate between the language there because being laid off and fired are two different things. Tanya already discussed layoffs earlier, and layoffs don't involve compensation. They never require that. There are a few situations where you can be fired without compensation. The main one would be if you're fired with cause, and that's a fairly high standard that needs to be met. It won't be considered to be with cause if it's just, your performance is a little subpar or you had some personality conflicts with a supervisor. It has to be something more serious, like violence in the workplace, theft, or as we discussed in our April 6th webinar, lying about being sick. That's considered cause for dismissal because courts have held it destroys the trust that is necessary between an employer and employees. Another situation where you could be fired without compensation would be if you're an independent contractor. As was also mentioned earlier in this webinar, when independent contractors have their working relationship with a business terminated, they do not have the same entitlements that employees do with regards to notice pay or severance. You should also beware of another category, which is called the dependent contractor, which was also just discussed more in depth in our April 6th webinar. But I'll give you a very brief explanation of what a dependent contractor is. That's sort of an intermediate level of a working relationship. And the two requirements are that there's a degree of exclusivity. So at least 50% of that contractor's business has to come from the one in or business. And they have to have some amount of economic dependence on that business. And if those are present and they are found to be a dependent contractor, then they would be entitled to notice and severance as an employee would. Next slide, please. Are there any other questions at this point? Okay, so our next poll, it deals with quitting during the COVID-19 pandemic. I know in our poll at the beginning, that was something people were interested in. So are there situations where an employee would still be entitled to employment insurance, EI, or CERB if they quit during the COVID-19 pandemic? Your options are A, they could still be entitled to EI but not CERB. B, they could be entitled to CERB but not EI. C, they could be entitled to both, or D, unsure. So go ahead and plug in your answers and we'll give you a couple moments.
So about 5 more seconds.
Right, and if we could go to the next slide, please.
Well, the answer they said is A, the majority.
And the majority was correct. You could be eligible for EI still, but not CERB if you quit during COVID. So as that implies, if you quit during COVID pandemic voluntarily, you absolutely do not qualify for CERB. As mentioned before, the CERB is for people who have stopped working as a result of the COVID crisis, but the government's been very explicit that it does not apply to people who quit voluntarily. Now, with regard to EI, the general rule is that employees who voluntarily quit without just cause are ineligible for the regular benefits, but they can still be eligible for other benefits like maternal or sickness benefits. And one other exception is if you have a fixed term contract. So your contract says you're employed for 1 year, 6 months, anything with a fixed term. If you quit within 3 weeks of the date that your work term was supposed to end, you won't be eligible for EI until that date passes, but following that date, you are eligible for EI. So just to explain what voluntarily leaving means, it means that it was the employee, not the employer, who made the decision to end the working relationship. And it will be found to be without just cause if the employee doesn't first try and explore all other reasonable alternatives that are available to them. So that could include going to your employer and requesting that maybe you be transferred to another division with a different supervisor if the problem stems from an issue you have with your supervisor. Could be requesting a transfer to a different location if you've moved far away from your current location. Could be requesting to work from home or just a modified schedule. Really what this means is that the onus is on the employee to see what options are available to them before they quit voluntarily, or else it will be considered without just cause. And if we could go to the next slide, please. We have a few examples of what will be considered just cause for quitting. These include being harassed in the workplace, being discriminated against, having major changes in the terms of your employment, like the amount of your salary or some of your responsibilities, or being pressured by other employees or coworkers to quit. Now, if you've watched any of our previous seminars or have been present since the beginning of this one, you might recognize that many of these scenarios that are listed here are the type of things that would give rise to constructive dismissal. So you are allowed to bring a lawsuit for constructive dismissal and still collect EI at the same time. However, If you do end up receiving payment for notice or severance or any termination pay, either through a settlement with your employer or through a court judgment, you do have to pay that amount that you collected from EI back. However, the repayment to EI is without interest. And once it's paid, you are given back the entitlement to EI that you used up during the months that you were collecting it. Next slide, please. Okay. And we have a couple more questions. The top two, firing employees refusing to come to work during COVID-19 from NN, and just discussing work refusals from TS. We are running a little short on time, and these are fairly complicated issues, but I will let you know we have discussed them in fairly decent depth in our June 8th webinar. So if you go to our YouTube page and go to the 9-minute and 48-second mark of that webinar, both of those topics are discussed pretty extensively. So another question deals with equality in the workplace, and that comes from TW. It's kind of a two-pronged question. One of them is, can you fire an employee who's posting racist commentary on social media? So the quick answer to that is that it sort of depends. It's gone both ways. There have been some for-cause dismissals that have been appealed at either labor tribunal or in the courts. And the courts have found that there was cause when someone was fired for making racist social media posts. However, in a lot of those cases, the material that they posted was highly offensive, and a lot of the time these were repeat offenders who had a pattern of doing these type of things. And the court put significant weight on whether or not they showed any remorse. So if they didn't, a lot of those people have been found to be fired with cause. However, there are also cases where for-cause dismissal has been overturned in cases where it was an isolated incident that the worker posted racially insensitive comments, and they deleted the post and were very remorseful, made public apologies. So those people were found to be terminated without cause and were either entitled to some notice pay or were reinstated in their previous position. And the other question has to do with obligations that employers would have to investigate when a racial complaint is made in the workplace. So that is sort of similar to when a complaint is made in the workplace regarding sexual harassment or assault or other sexual misconduct. And so the process would really be very similar. And what you're supposed to do in these situations is you commission a workplace investigation. And you do that by appointing an independent investigator or investigators. And you have them conduct an investigation, which would involve interviewing employees of the business and anyone who might have knowledge of the behavior that was the subject of the complaint. And then they would issue a report. And one thing that's very important is that the investigation be initiated and the report issued very promptly. It's not something that you can just sit on your hands about and decide to investigate it somewhere down the line. You try to really get on top of this. One interesting practice tip that we can provide from our own experience when dealing with sexual misconduct complaints, it's always best practice to have multiple investigators of different genders who can conduct interviews and the investigation. So you can kind of make the comparison. If it's dealing with a racial complaint, it would probably be a very good idea to have different investigators of different races who are handling the investigation. I hope that answers the question satisfactorily.
Thank you, Jordan. So we have about 1 minute remaining. I want to know if anyone has any other questions. You can type them in fairly quickly and we'll respond. We responded to as many questions as possible when you registered. So if there's anything over and above that, please let us know. While you are typing, I'll let you know that you will receive an email after the webinar is uploaded with a copy of the webinar, because I understand some people need to, they might come and go or not even be able to participate. This webinar is also broadcast on Facebook Live. I just saw something, a chat. Oh, you're welcome for KP for arranging this. And so you please provide us your feedback, what you liked, what you didn't like, what we can improve on, what you want us to talk about in the future. We customize this for you. We think it's very important for you to be able to learn as much about employment law because the law is changing every day. And if you have any old technology, please consider donating it so then we can in turn provide it to Renewed Computer Technology, which is funded by the federal government. And thank you again to our partners for helping to promote our webinar to your contacts, institutions, businesses, and people. Really, really appreciate having your support. And it's 1 o'clock right now, so I will, and there aren't any more questions. So I just wanted to say thank you to Jordan. Thank you to Rishi for joining us today. Rishi did most of the legwork here, so thank you for doing all that work. Excellent. You're turning out to be an excellent lawyer. And I want to thank you all for participating in your questions. I hope you stay safe and healthy. Have a wonderful day.
Thank you, everyone.
Thanks.
Thank you, everyone.
Bye, Alba.